So with your permission, my lords, my ladies, if I can start the submissions on behalf of the Honorable the Attorney General.
Yes, you may.
My lord, my ladies and my lords, I'm sorry to interrupt the Solicitor General. We have a small application to make which will not take more than 2 minutes because it's a straightforward housekeeping issue. And we got served last night.
What is it, Senior Professor Kendiki?
I'll allow Mr. Mutuma to address the court for 3 minutes or less.
Thank you, Your Lordship, and my ladies. We want to make an application in respect to 2 affidavits that we would like them to be struck out of the record. Now, via our notice of motion dated 8th of June 2021, we filed an application under Rule 29 of the Court of Appeal rules, seeking to adduce further evidence in form of the JLAC report. That application was allowed on 25th of June 2021, and the court, in its ruling, indicated that any party who wishes to respond to our affidavit to do so by close of business yesterday. We have received 2 affidavits, one by IBC, sworn by Michael Goa, and another one by BBI Secretariat, sworn by Dennis Waweru on 27th of June 2021.
Yes.
Now, the said affidavits seemingly are in response to our affidavit adducing the JLAC report, but a close look at the said affidavit speaks otherwise. I will begin with the affidavit by IBC, where IBC seeks to introduce new evidence that has nothing to do with the JLAC report. What they're seeking to adduce is a Gazette notice dated 16th September 2020, confirming that there has been an ongoing voter registration. Now, this is an issue that was brought up at the High Court. IBC did not respond to that issue by adducing that Gazette notice. I note the Gazette notice is dated 16th of September 2020, so there was nothing that prevented them from adducing that piece of evidence at the High Court. It would then appear that they are trying to cure defects in their response at the High Court by sneaking in this piece of evidence at this juncture. My view is that they ought to have sought leave, just like the way we did, to adduce that Gazette notice.
When was that affidavit filed?
That affidavit was filed yesterday, my lord, and it's dated 28th of June.
Did it comply with the times?
Yes, it complied with the timelines that the court had issued in respect to the response to affidavits, but our contention is that it does not respond to the JLAC report. It seeks to sneak in evidence that was not availed at the High Court. So in that respect, I'll be asking the court to expunge or strike out paragraph 5 and 6 of that affidavit, together with the Gazette notice that has been annexed thereof.
Not the entire affidavit, just paragraphs 5, 6, and the Gazette notice?
Correct, my lord.
I'm not sure whether we have even seen the affidavit.
Perhaps the court can take time, and it is dated 28th of June 2021. I believe it was filed yesterday by IBC. It is important for the court to look at those specific paragraphs before making a ruling on the same.
That's all?
Yes, in respect to the other affidavit, sworn by Dennis Waweru, it is a 1-paragraph affidavit it seeks to introduce a JLAC report on the referendum bill of 2020. Now, this is a bill that is distinct and separate from the BBI Constitutional Amendment Bill. It would then appear that this part of bill is being introduced to cover gaps in respect of the lack of legal framework in the processing of a constitutional amendment bill by way of a popular initiative. Again, it does not even seek to respond to the affidavit of Meroru Waweru on the JLAC report. It is just a new piece of evidence that is being introduced at this juncture. Again, it does not comply with Rule 29 of the Court of Appeal rules. It is purely being brought again to improve their case. I note that the referendum bill that is being sought to be introduced, rather the report, is dated October 2020. Again, there was no reason as to why the BBI team could not have adduced this piece of evidence at the High Court. This, in our view, my lords and my ladies, amounts to trial by ambush, and it's a way of sneaking in evidence at the Court of Appeal and procedurally. That's all, my lord and my ladies. Thank you.
So can IEBC and BBI Secretariat just respond quickly?
If it may please, my lords and ladies, the response is really very simple. First of all, the responses were filed within time. Secondly, to the extent that the applicant on this issue sought and was allowed to adduce new evidence, it is not in their province to determine how the respondent should respond to that new evidence. The question of relevance is for the respondent to that issue, not for them as the applicant. More importantly, my lords, as indicated, they sought to introduce a report that was not before the trial court, the Justice and Legal Affairs Committee report. And as demonstrated, they did not produce the complete report. That report refers to an annexure, which is an additional report of the JLAC committee dealing with the referendum bill. That is the only report that is now produced in response to complete the new evidence that they have brought before this court. They cannot say it could have been produced before the High Court because they had not produced the JLAC report in order to complete it. Most obliged, my lords.
My lords and my ladies, on behalf of the IBC, first we want to associate ourselves with...
Sorry, this is for record purposes, Mr.?
My name is Gumbo Eric.
Okay. Yes.
So my lords and my ladies, first I would want to associate myself with submissions from learned senior counsel, Mr. Otiende. Secondly, I would want to point out that the issue or the annexure that is in our affidavit, first, is a gazette notice, which ordinarily would be a public document. Two, that in addition to that, the JLAC report that was filed with the leave of the court, and we did mention this in our replying affidavit, introduced a number of new issues. We didn't want to come and make that application again that we respond to those new issues, which then would have had the effect of delaying these proceedings. The singular issue that that Gazette notice responds to is just a confirmation of the fact that there's been indeed continuous registration of voters and nothing more. My lords and my ladies, if you look at one, the JLAC report itself and the Hansard that is with it, the deliberations that have been presented before you are of such a broad nature as to cover each and every aspect of the petition that is before you. In the event that we don't have that evidence or that Gazette notice for purposes of responding to those issues, my lords and my ladies, we shall stand prejudiced. It is not introducing anything new. The question of continuous registration of voters has been before you. There's nothing new that has been introduced. That will be all, my lords and ladies.
Sorry, Council, can you connect the issue of the JLAC report and the continuous registration of voters? Let's get that connection clearly.
Yes, my lord. So what I indicated is that other than the JLAC report itself, we also had the Hansard, which was part of the documents that were introduced with the leave of this court. The deliberations that went on, both which are contained in the JLAC report, as well as in the deliberations, are such as to cover every single spectrum that this petition is dealing with. So to that extent, if we do not get an opportunity to respond to some of those deliberations, which would be available to the respondents for purposes of the proceedings that would be before you, then we'll stand prejudiced because we'll not have had an opportunity. And I said, my lords and my ladies, in our replying affidavit, we did mention that that was the risk that that leave was going to then place us in, because it was going to introduce issues which we thought we would not have had an opportunity to deal with. One of them is that question of registration of voters, because it is an issue that also was touched on if you look at the Hansard that was that supported the report.
Okay.
I'm most obliged.
In a brief rejoinder, my lord.
I would request, for purposes of recording, whenever counsel you stand there, just say your name, even if it is for the 10th time, because the transcription needs to record that.
Much obliged, my lord. My name is Elias Mutuma for the 19th, 20th, and 21st respondents in Appeal 291. In a brief rejoinder, my lord, in respect to my learned senior counsel, Otiende Amolo, the affidavit does not in any way state that they are seeking to introduce an annexure to the report that we had sought and was granted leave to adduce. In fact,
just one capful of Dettol is enough to disinfect surfaces and protect your family and your home. Dettol, tested effective against COVID-19.
This message is brought to you by the Ministry of Health and JQuat with support from the European Union.
Along came love. David and I love each other so much. And that is the reason we're getting married, so we can finish uniting the beautiful family that we are.
No, and it really hurts that David still hasn't realized the kind of garbage that you are.
It's a bit complicated for me.
This is not the life that you promised.
It's your fault we're here, Perla.
Mine?
Yes. You trusted Carito, so now you have to face the consequences. Along came love.
To report gender-based violence, call the toll-free line 1195, download the Komesha the Luma app, or dial *483*306#. Kua bazu true.
So you want me to stick around a man who cheated on me?
Better the devil you know than the angel you don't.
Yani, you're hitting on me, no kuna Joey.
What?
Are you seeing anyone?
Oh no, I'm seeing several men.
That's the thing I like about Sandra.
Oh.
She's nothing like you.
I don't think she's a good friend. She's so flirtatious.
Aye, jokes kidogo tu.
Yummy. I know, Nitamu. It's no surprise. The good quality baked bread from Ball A is festive good. Chukua yako moja leo.
Because I know what's about, jokes about. All my guys, they want to not tired. Oh, yeah, no. Because I know what's about, jokes about. All my guys, they want to not tired.
To get Boys Are Bad by Keys Daniel, dial *812*802#. Skiza, non-nation.
No bunga gini kabok ni misteri. No bunga pagi pendenele ni misteri. No bunga ti browse on flick ni misteri. No bunga ni gana next week ni misteri.
Only on the trend. 10 p.m.
We have moved. The Nation Media Group Kisumu office is now located at Mega Plaza along Oginga Odinga Street, Wing A on the 6th floor. Contact our customer care desk for more details on 0719 038931 for assistance.
On behalf of the 76th respondent, who is Moraro Moke, my Lord, I would not ordinarily have stood, but the reason I'm constrained to come here is because this issue of voter registration was raised in the petition that Mr. Moraro Moke filed at the High Court. As you make your decision on whether the IEBC should be allowed to introduce a gazette notice showing that there has been continuous registration all along, my Lord, I will invite you to look at paragraph 769 of the judgment of the High Court. And the reason this is important, my Lord, in the High Court, the official position of the IEBC, according to that paragraph of the judgment, was that the last time the continuous voter registration was done was just before the by-election for Kibra constituency in the year 2018, about 3 years ago, my Lord. And now they are coming before you, having told the High Court that, to tell you, actually, we have been doing voter registration all along, and we have a gazette notice to show it. A gazette notice that was in existence at a time when they told the High Court a very different position.
My Lord, we're asking you to note that. It's on the record. And for that reason, we will very humbly urge the Honorable Court to strike out that Gazette notice. They are trying to close the stable long after the horse has bolted. Thank you, my Lord.
Now, the view of the court is that we want to give a short ruling at 11:30 when we return from our tea break. I do not know whether the issue relating to that affidavit and the Gazette notice is one that is going to feature in Mr. Ogeto's address of the appeal. I don't think it is. It will come later. And if the issue will come later, we would then want to rule on it after we adjourn at 11.
Lords, to be of assistance to the court, this is not a matter that is featuring in our submissions, and we can proceed as proposed by your lordships and your lordships.
So just 1 minute. So I have briefly recorded that we shall make a ruling on the question of striking out the two affidavits as raised by counsel at 11:30 when we resume after tea break. So you may continue, Mr. Ogeto.
With the kind indulgence of the court, my name is Kanjama Advocate, and I request to address the court before my colleague proceeds.
Mr. Kanjama, what's the issue? Mr. Ogeto, just take a brief, take a seat briefly.
I also seek to address the court on a separate issue.
Your microphone is not on.
My name is Charles Kanjama. I also seek to address the court on a separate preliminary issue, and I will be brief. My Lord, there have been three decisions of benches of this court on the question of who can participate in these proceedings. The first was issued on 2nd of June 2021, in which, in order number 2, all parties who had filed notices of appeal or intended appellants were given access to these proceedings, and this order was issued after I addressed the bench that was sitting on that date. My Lord, there was a ruling issued by a different bench yesterday, 28th of June, which allowed two amici who are not present in the proceedings in the High Court to also participate in these proceedings. And both of those rulings were facilitative of persons who intended to participate in the appeal. And there was a third ruling also issued yesterday, which restricted participation by myself in these proceedings and struck out a memorandum of appeal that had been filed by myself on the basis of two applications, one by IEBC and one by the Attorney General. The application by IEBC was never served upon myself, and the submissions that I prepared in response to the application by the Attorney General, I say seem with hesitation, seem not to have been considered by the court. Therefore, my lords, my ladies, I did file an application dated 28th of June seeking a second look by the court at the order that was issued yesterday. My lords, I note, my ladies, I note that my firm and myself have already been put on record in Appeal E291, which is the appeal that is proceeding, and pursuant to directions given by the Deputy Registrar, after the orders of this court of 2nd of June, we were requested to file a distinct appeal as an intended appellant, which is appeal number E307. And so there is a question that needs to be clarified as the court begins the hearing in regard to whether that appeal E307 shall be canvassed together with the other consolidated appeals. My lords, my ladies, when there is a momentous substantive appeal such as this one, the court also has a great opportunity to make momentous determinations on procedural matters that can clarify certain questions of procedure and law that the court has previously taken divergent views from time to time. And so we are urging the court to allow us to give a decision on this application and to allow us to submit on it. There are three issues that we'll be requesting the court to consider. One is the question of locus and right.
No, don't argue now.
Yes, I'm not arguing. I'm just mentioning the three issues, my lord, kindly. One is the question of, if that's okay.
Mr. Kanjama?
Yes.
The president says, don't go into what your application is about until the court decides whether or not we will hear you. Perhaps it might be nice to respect that.
Precisely. And Mr. Kanjama, the bench, the presiding judge of the bench that heard your application yesterday, the Honorable Lady Justice Okwengu, may have something to say regarding that application.
Most obliged. I'm sorry for having appeared to have disrespected the court. It was not my intention. I'm very sorry.
It's fine, Mr. Kanjama.
Thank you, Presiding Judge. Mr. Kanjama, upon receiving your request for review, we have checked and we do have communication from IEBC indicating that they served you with their application. We also have the replying affidavit which you have responded to, that you filed in response to the application by the AG. The application by the AG and the application by IEBC were, in substance, similar application. They were all seeking to have your notice of appeal struck out, and you denied the opportunity of appearing in this matter. So, we believe that you are served because we have that indication from IEBC. We also believe that even if we are to accept what you are telling us now, that you are not served, and we are to review that order to the extent of setting aside the part that relates to the application of IEBC. I don't think it would change matters much, because there is already an order that is barring you or rather not barring you, but restricting you from participating in this appeal. And that order, insofar as the Attorney General is concerned, you are not challenging it. So I think that what you are telling us now is really more of an academic exercise. It will not change the situation. Thank you.
So Mr. Kanjama, you have heard the view of the bench to which you have sought a review of yesterday's ruling. So we want to proceed with this appeal.
My Lord, could I very kindly just address the court on, for 1 minute on the procedural issue that is before you. I was just saying that yes, I have heard and I've respectfully listened to the directions that have been given. I however plead with the court, since I'm now before a 7-judge bench, to at least allow the applicant to articulate his application, because the application is not seeking to appeal against the decision of the High Court issued in March.
All right, Mr. Kanjama, since we are going to make a brief ruling on the other issue at 11:30,
yes,
we will also address your concern. So that will be at 11:30.
Could I request to address the court before it makes a ruling on my application? But no, I'll be guided.
No, Mr. Kanjama, there is an application in writing, and we know what you have said in your request for review. And so we will look at that supplemented by what we have so far heard from you. So I request that you take a seat and let Mr. Ogeto proceed. Kindly.
Most obliged.
My Lord. With your permission, my Lord, this is Professor Migaya Kech, amicus. With the permission of the court, kindly allow me to confirm that I filed and served my brief pursuant to the orders of the court issued yesterday. I also confirm that I'm at the disposal of the court. Thank you, my lords, my ladies.
My lords, just very briefly, Elisha Ongoya here. I don't know whether my microphone is on. Thank you. Just very briefly, so that you give a direction together at 11:30. There is a direction in the ruling regarding admission of Professor Migaya Kech.
I don't know whether your microphone is on. We can't hear you.
I trust I can now be heard. Thank you. My name is Elisha Ongoya. I represent the 74th and 75th respondents. And I address you regarding the...
Mr. Ongoya, perhaps you could give us the name of your client instead of just the number of the respondent.
Let me just pick...
You have to confirm from the record who your client is?
I'm leading counsel on record, my lords. I'm leading Mr. Ogada. My name is, I appear for Justice Juma and Isaac Ogola, leading Mr. Ogada in the matter.
That is, I will say Ogola?
And Juma.
Yes.
Thank you. So, very briefly, regarding the joinder or the admission of two amici, Professor Migaya Kech and Professor Charles Fombard, the respondents were directed to serve any submissions to their submissions within 24 hours from service. We've just been served this morning on our way to this court at 8:03 in the morning and 8:13 in the morning. It's therefore practically not possible to respond within 24 hours, since we will be here up to late this evening. I was requesting if we could be given up to the last hearing date of these proceedings, so that we have a practical opportunity to prepare and respond to those submissions. That's all.
Mr. Elisha Ongoya, when urgent matters come before court, they must be dealt with expeditiously.
Correct.
And therefore, you will have to burn the midnight oil. You are a team of lawyers. Someone could be preparing whatever documents you want to put in while you're here, and therefore I think we will stand by the order that we made.
Fair enough. I'm guided, my lord. I just wanted to bring it to your attention, but I'm guided.
Thank you.
My lord, my ladies, with your very, very kind indulgence, again, my name is Gumbo. I want to plead with you, my lord, to just give me 1 minute to be able to make an observation in relation to what Dr. Mutomi Tankolu mentioned to you. The disadvantage that I had is that he spoke after I had addressed you. And then he raised an issue which I didn't get an opportunity to perhaps mention or give any indication on. He introduced an issue in relation to paragraph 734 of the judgment, and then made a comment that the reason why we are seeking to introduce the Gazette notice is so that we run away from the position that we took in the High Court. My lords and my lady, I wanted to just point out that quite perhaps number one, and more very importantly for us, that issue is one of the grounds of appeal that we have. The issue of the mischaracterization of continuous registration of voters. And you heard Dr. Diankolu say that we talked about revision of the register. My lords and my ladies, the issue that then we'll need to make clear in the main ground of appeal is the mischaracterization of the use of the word revised and continuous registration of voters. So kindly, my lords and my ladies, have that in mind, because it is an important issue that arises from a misreading of those two statutes. Most of that.
All right. I hope we can now continue. We have spent about 35 minutes on some procedural aspects. I think it is not time wasted, but we must be able to move on. Mr. Ogeto, you are just beginning. And so the time will run from now, your 2 hours. It is 10:07. Proceed.
Thank you very much. My lords, my ladies, let me start, my lords and my ladies, by saying that it will be amiss of me not to say how deeply honored I am this morning to appear before you on behalf of the Honorable the Attorney General. And before I proceed, my lords, my ladies, I know you had given us 2 hours to do our submissions, and that applies to all the appellants. But I just want to point out to my lords and my ladies that the team of His Excellency the President has very graciously donated 30 minutes, 30 extra minutes to us. And that is the result of the fact that we cover much more ground in terms of our grounds of appeal. And so, my lords, I just want to notify the court that instead of the 2 hours, we also have 30 minutes from His Excellency the President for us to be able to be helpful to the court.
Well, that's what we said in our direction. As long as the issues that you're covering are cross-cutting, and those who are coming after you will not be requiring to take an equal amount of time on the same issues. It is okay, as long as you've organized yourselves.
So thank you very much, my lord and my lords and my ladies. My lords, we have filed 31 grounds of appeal, and those grounds will be found at page 1 of our volume 1 of our record of appeal. But we propose, my lords, to argue those grounds in the form of thematic areas. And allow me, my lords, to outline those thematic areas and to place our appeal in proper context. The first...
How many are the thematic areas?
The thematic areas, my Lord, are 9 thematic areas. The first thematic area is the applicability of the basic structure doctrine, and that will cover grounds 1 to 5, 17 and 18. The second thematic area will be the constitutional remit of popular initiative and the question of public participation, grounds 7 to 17. The third thematic area, my lords, my ladies, the creation of additional constituencies, ground 24. The question of presidential immunity, the fourth thematic area, that will cover grounds 19 to 23. The fifth thematic area, the quorum of the Independent Electoral and Boundaries Commission, grounds 25 and 26. The sixth thematic area, adequacy of legal infrastructure to support signature verification, grounds 27 to 29.
Yes.
The seventh thematic area is the single or multiple referendum questions, ground 31. The issue of voter registration as relates to holding of a referendum will be the next one. And finally, and that will cover ground 30. And
yes.
Finally, the question of the role of amicus curiae, ground 6.
All right, start with the number 1, the applicability of basic structure doctrine.
My lords, the way we want to do that is that my colleagues will handle each of those thematic areas.
Right.
But for me, I want to give you highlights of the essential aspects of our appeal. Then I'll let my colleagues deal with the specific aspects of these thematic areas. In other words, I just want to do an opening statement, my lords. My lords, let me start by stating at the outset that our appeal is nothing more than a plea to this honorable court for fidelity to our Constitution. It is simply a call to this honorable court for the restoration of the people's sovereign will. Through our appeal, my lords, my lords, we invite this honorable court to affirm the Constitution as enacted by the people of this great republic. We also invite this honorable court to affirm that it is not for this court or for any other court to rewrite our Constitution. My lords, my ladies, our submissions will seek to demonstrate, among other issues, that, 1, the learned judges of the High Court disregarded clear provisions of the Constitution in order to arrive at their decision. 2, the learned judges effectively amended the Constitution. 3, the learned judges of the High Court disregarded decisions made by their colleagues in the High Court, in the Court of Appeal, and indeed the Supreme Court. And 4, the learned judges disenfranchised millions of Kenyan voters by ignoring their popular initiative. We will be submitting that the judges did this through personalized attacks against His Excellency the President of the Republic of Kenya that climaxed in factually and legally unfounded conclusions. An example of this, my lords, my ladies, is the unprecedented finding that a president can be sued in a personal capacity for official acts. On the disregard of the Constitution, my lords, my ladies, we will demonstrate that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords, my ladies.
Just wait. Can you just repeat? The plane was passing by making noise. Just repeat.
Sorry, my lady.
Before you come to, just repeat what you are saying. Before you come to what you want to start on now.
My earlier submission, my lord?
No, her ladyship is saying that there was loud noise from a passing helicopter. She requests that you repeat what you just said, the last statement. I think about the basic structure.
After the personal attacks to the president.
Okay. On the disregard of the Constitution, my lords, my ladies, we will demonstrate.
I think, Mr. Ogeto, the last thing you addressed before the plane took your voice away was something about the Constitution having no place for something, for the basic structure, I think. That's what you need to repeat for us to get it right.
Yes, and what I'm saying in our submissions, my lords, my ladies, is that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords and my ladies, provides that our Constitution may be amended either through parliamentary initiative or popular initiative. The chapter confirms that all the provisions of our Constitution are amendable. Articles 255 and 257 in chapter 16 direct us in very clear detail how the Constitution may be amended. The provisions, my lords, my ladies, tell us which amendments require a referendum and those that do not require a referendum. The provisions prescribe the majorities required in either House of Parliament to pass an amendment. They also guide us on the majorities required to pass an amendment in a referendum. We submit, my lords, my ladies, that there is no limitation to this amendment power. Our Constitution, in other words, is self-contained. There is no room for drawing inferences on the rules of amending the Constitution or for relying on extraneous factors. There is no mention in our Constitution of unamendable or eternal clauses in our Constitution. The learned judges themselves admitted as much in paragraph 473 of their judgment when they noted, and I quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." End of quote. Yet, my lords, my ladies, the learned judges proceeded to conclude that the basic structure doctrine was applicable in Kenya. To be clear, my lords and my ladies, many of the democracies desiring to make their constitutions unamendable have done so explicitly. And we have examples which we have articulated in our submissions. Germany, Italy, France, Senegal, Gabon, and Morocco. We shall submit, my lords, my ladies, that courts have adopted the basic structure doctrine where amendments are exclusively by Parliament. We do not have a single decision globally where courts have declared that the basic structure doctrine applies in a situation of a referendum.
Perhaps, Mr. Ogeto, when you get to the meat of that, you might want to address the issue of Colombia when you get to the meat later on.
We will do that, and in Colombia, what they've done, my lords, because we have looked at that constitution, is that where the intention of the makers of the constitution intended that you have a constituent assembly, they provided for it expressly in their constitution. We shall demonstrate that the people of Kenya consciously and deliberately avoided the basic structure doctrine. They chose a different method of safeguarding the fundamental provisions of their constitution. This method is what is laid down in chapter 16. Once this method has been followed, the people of Kenya can amend any provision in their constitution. Chapter 16, my lords, my ladies, was our balance between hyper amendment, which was the concern of the High Court, on the one hand, and rigidity on the other hand. And we invite my lords and my ladies to look at the final report of the Constitution of Kenya Review Commission, 2005. This report, my lords, emphasized the need for this important balance at page 74 of that report. And we have reproduced that report.
Yeah, where is it contained in the record of appeal, please?
Contained at page 12 of the amended case digest and pages 49 to 51 of the appellant's abridged bundle of authorities. And if you allow me, my lords, my ladies, just to quote briefly from this report, they quote what they say: there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, and that is important, my lords, a balance must be struck between these two extremes. At page 75 of the report, the Commission proceeds as follows, and I quote: many Kenyans expressed fears that even after a comprehensive review of the Constitution, Parliament, and the emphasis on Parliament, Parliament may thereafter sit and make substantial amendments that would water down all their efforts. In addition, it was generally felt that the current provision for amending the Constitution was too simple and therefore been used to consolidate power in the executive. The people, therefore, wanted fairly rigid arrangement, the amendment of which would require their participation in some form. This is what the CKRC report says. On this basis, my lords, my ladies, at page 76 of that report, there was a recommendation for a distinction in the amendment procedures for entrenched provisions and non-entrenched provisions. And my lords, my ladies, this distinction in the CKRC report is exactly what is reflected in chapter 16 of our Constitution. This chapter captures the people's concerns and aspirations with regard to the power to amend the Constitution. We submit that it balances between rigidity and amendability. There was never an intention to make certain parts of our Constitution unamendable, because if that was the case, then the makers of our Constitution would have expressly stated so in the Constitution. My lords and my ladies, we shall demonstrate that in practice, Chapter 16 has been very successful in safeguarding the Constitution against the culture of hyper-amendment. You will notice, and we have demonstrated that in our submissions, that since the promulgation of the Constitution, there have been approximately 22 failed attempts to amend it. 2 through popular initiative and 20 through parliamentary initiative. And we have detailed those in Schedule 2 to our submissions dated 8th of June 2021. On the second issue, my lords, my ladies, we shall show that the learned judges effectively purported to amend the Constitution under the guise of interpretation. In paragraph 474G of the judgment, the learned judges say that the purportedly unamendable and eternity clauses would be determined by the courts on a case-to-case basis. My lords, my ladies, we need to note this very carefully. And if this understanding is to hold, the courts would have the role of vetting proposed amendments before the same are dealt with in accordance with Chapter 16. And yet, my lords and my ladies, there is no such role for the courts in our Constitution. In paragraph 615 of the judgment, the learned judges held that each of the proposed amendment clauses ought to be presented as a separate referendum question. We submit, and we will provide details in our submissions, that this holding clearly contradicts Articles 257(10) of the Constitution, which identifies in very clear terms that an amendment bill as the subject matter of a referendum. In paragraph 546 of the judgment, the learned judges impose limitations on presidential immunity. This, again, we submit, my lords, my ladies, contradicts Article 143 of the Constitution, which gives a serving president absolute immunity from civil proceedings while exercising his official functions. On the third matter, my ladies and my lords, we shall show that the learned judges ignored court decisions from their own High Court, the Court of Appeal, and even the Supreme Court. In this regard, we shall point out the following. 1, the learned judges ignored decisions to the effect that Chapter 16 provides adequate means for amending the Constitution. And 2, just as illustration, the learned judges ignored a finding by the High Court that the IEBC, as currently constituted, are quorum. In paragraph 491 of the judgment, the learned judges claimed that the popular initiative mechanism is exclusively available to the private citizen, as opposed to a state organ or His Excellency, the President, or more generally, the government. My ladies and my lords, we shall show that the learned judges established a non-existent dichotomy in the use of the popular initiative. And by this, the learned judges disenfranchised nearly 4 million registered voters under the pretext of nullifying alleged unconstitutional acts by His Excellency the President. Our very humble view, and with utmost respect, my lords and my ladies, is that the essence of a popular initiative is that it has to be popular by satisfying the majorities stipulated in the Constitution and nothing more. The initiative only becomes an initiative upon obtaining the endorsement of at least 1 million registered voters. The Constitution is very clear. It does not provide for the origin of a proposal to amend the Constitution through popular initiative. There is also no basis, my lords, my ladies, for the claim that the popular initiatives are by definition anti-government, because this was the finding of the Superior Court. And you will notice, my lords, my ladies, that this regrettable claim resulted partly from the learned judges' reliance on Wikipedia. They resorted to Wikipedia as an authority. And for sure, Wikipedia cannot be a reliable authority for anything serious, my lords, my ladies. If you look at Wikipedia, if you do a Google search of Wikipedia, it describes itself, and I quote, the free encyclopedia that anyone can edit, end of quote. So therefore, my lords, my ladies, a source that is so open to manipulation cannot be a reliable source of legal authority. In paragraph 490 of the judgment, the learned judges held that the Constitution of Kenya Amendment Bill 2020 is an initiative of His Excellency the President. My lords and my ladies, this was a fundamental factual error on the part of the judges. To be clear, we will be submitting that nothing in the Constitution prevents His Excellency the President from originating an amendment proposal to the Constitution. Even so, in the present case, my lords and my ladies, His Excellency the President never played the role that the learned judges claimed that he did. The learned judges simply ignored the evidence that was adduced as to who the promoters of the amendment bill were. And with utmost respect, my lords and my ladies, it seems to us that the learned judges were keen on very personalized attacks against the person of His Excellency the President. To them, the facts and the law did not matter. Neither did precedent nor the sovereign will of the people of the Republic of Kenya. The person of His Excellency the President just had to be found at fault, regardless of the consequences of such a finding on the people of Kenya and their sovereign power. In sum, my ladies and my lords, we will demonstrate that the learned judge's verdict was only possible because they either ignored or amended the Constitution and the law. At the end, the judges elevated their personal opinions and preferences over the Constitution and over the will of the people of this great republic. And therefore, my lords and my ladies, our plea to this honorable court is that it reverses the extra-constitutional and anti-constitutional step taken by the High Court. We urge the court to affirm the letter and the spirit of our Constitution. My lords and my ladies, we humbly invite you to end this clear on-song, and we call it on-song, in a very considered manner, on the sovereignty of the people of Kenya. We submit that the people must retain their sacrosanct right to live by the constitution that they chose for themselves and to develop it as they may wish. That is the only way to preserve a rule-based civilization. And I wish to quote the famous Irish philosopher Edmund Burke, who has warned us, and I quote, "A state without the means of some change is without the means of its conservation," end of quote. My lords and my ladies, as I conclude, and with your kind permission, I should like to indicate that my learned colleagues will address the various topics of our submissions in the following order. Mr. George Oraro, Senior Counsel, who is leading us, will address the question of the applicability of the basic structure doctrine, public participation, and the approach to referendum questions. Mr. Kamau Karori will address the question of the remit of popular initiative and the creation of additional constituencies, and the quorum of the IEBC. He will also deal with the question of amicus curiae. With your permission, I will return to address you on the question of presidential immunity. My learned friend, Mr. Nyamodi, with your permission, will be replying to the respondents' submissions. Thank you very much, my lords.